Good afternoon. Welcome, everyone. My name is Angie Vosing, and I am PACO's president-elect. Welcome to the May 18th, 2023 session of the Workers' Compensation Roundtable. A few announcements before we get started. First, we always want to thank Spectrum Reporting for providing our Zoom link and recording today's session. Today's session is being recorded, and in a couple of weeks we'll have that put up on the PACO website under the members only tab. So if you missed today's session, you can catch it later in a couple of weeks. I hope that everybody enjoyed our Paralegal Day celebration on Monday evening. It was a wonderful evening. It was a wonderful venue. The food was terrific. Our keynote speaker, Judge Jade Page, did a wonderful job of sharing with us information on the different specialty courts in Franklin County. And I am waiting for information from her on how paralegals can get involved and help with those specialty courts that she talked about. So more information will be coming on that. Upcoming events on May the 25th, we'll have our Legal Insights session, and our presentation is on an interesting topic, the value of using a weather expert. So that should be really interesting. If you've not registered for that event, you can certainly go to the website and do so. Also, something that you will want to register for is our membership meeting on June the 13th. That's on a Tuesday. And that session that will be the time that our new officers will be installed. And get ready for this. It is in person. I am so excited to have an in-person meeting again. We will go ahead and have a live stream option for those who can't make it into the meeting in person. I know a lot of you work remotely or far away from downtown, and it's difficult to get into the downtown area. So you have the option to sign up to attend that meeting by live stream as well as in person. That will take place at the very brand new offices of the Columbus Bar Association. I'm excited to see what it looks like inside. And they have been gracious enough to allow us to use their space for our membership meeting and the installation of officers. So go to the website, check out the information on that, get registered. We'd love to see you there. And those are all of the announcements that I have, so we'll go ahead and get started. Today, I want to introduce to you my co-presenter, Jade Robinson. Jade is an attorney at Eastman & Smith. She graduated from Eastern Kentucky University for her undergrad and the University of Cincinnati for her JD. Jade is an associate in our labor and employment and workers' compensation practice groups. She concentrates her practice in the areas of diversity, equity, and inclusion initiatives, employee handbooks, employment discrimination, employment issues encountered by small businesses, regulatory and compliance issues, unemployment legal issues, and workers' compensation. Goodness, Jade, it sounds like you do it all.
I try.
During law school, Jade was part of the University of Cincinnati College of Law's trial team, and she also interned at the University of Cincinnati's Entrepreneurship and Community Development Clinic. She received the Tyler Short Outstanding Entrepreneurship Student Award for her work at the clinic, and it was this work that sparked her interest in assisting small businesses. She's a graduate of the Leadership Council for Nonprofits BOLD program, which develops professionals' nonprofit board skills. So you are definitely all over the place. You've got a lot going on. We will go ahead and get started then. Jade, if you want to begin.
Sure. Thank you, Angie, for the introduction. And I was excited to be able to talk to the group today about workers' compensation, specifically court appeals involving industrial commission orders, along with Angie. I'm going to be taking the first half of the presentation, and then I'll hand it over to Angie about halfway through. And of course, I'll still chime in respectfully when Angie would like me to, or maybe I'll just add my thoughts during her half, and you're welcome to do so as well, Angie, if you have anything to add during the first half. We want to start with an overview. So first we'll talk about exhausting the administrative process. And that's important to note that there are two sides to workers' compensation. One is the administrative side. Two is litigation side, which is our focus today. But you can't get to litigation without the administrative side, so we'll just talk about that briefly at the beginning. Then we'll get into the two different kinds of court appeals, the cause for filing an appeal, why you should, maybe why you shouldn't, certain deadlines that apply, the appropriate venue, and then the process, which is where the meat comes in of how paralegals and lawyers work together for workers' compensation claims when you're in litigation. So the administrative process, there are multiple levels. And before I get into the levels, I wanted to take a step back and explain how someone, a claimant, gets involved with the workers' compensation process to begin with. So a claimant who thinks that they have been injured at work, I'm going to be very biased on the employer side with my language today, so that they think they were injured at work is key, completes a FROI, a first report of injury, and this is what gets the ball rolling with the workers' compensation process and whether they have a right to participate in Ohio workers' compensation system. The employer could certify the claim and say, yep, they were injured at work, this happened, I agree, or they could fight the claim from the very beginning and say, no, it didn't happen at work. And that would be one of the things that the district hearing officer would hear. The district hearing officer hears basically all workers' compensation issues. They're the first administrative officer to hear those issues, whether it's temporary total, permanent partial. They have a wide range of issues that they hear. If either the claimant or the employer doesn't like the district hearing officer's decision, they can appeal to the staff level and have their issue heard before the staff hearing officer. Then, if either party doesn't like the staff hearing officer decision, they can appeal to the full industrial commission. However, these appeals, getting them actually approved and heard by the commission, are rare. So typically the commission will issue what's known as a refusal order saying, no, we think the SHO got it right here. We're not going to hear that. The reasons why the commission may decide to hear the issue is because perhaps it's a policy or precedent setting issue, something that's new and fresh, which doesn't happen in workers' compensation that often, but maybe it will with the new temporary total amendment that we've seen recently. They could also say, hear the issue because there's a mistake of fact, there's a mistake of law, there was fraud, or just an outright error. But less than 1% of all hearings are heard by the commission. So again, it's really rare that the commission will actually hear the issue. Then if either party does not like what the commission has decided, you can also submit a request for reconsideration, where the commission will again look at the issue and maybe change what's been done to date. Again, this is really rare. You need to meet basically the same burden that you have to prove for the commission to hear your claim the first time around. So again, the fact that it will be reconsidered is also very rare. Then once you get your refusal order, which is typically how it works if the commission doesn't hear the claim, is when you'll be able to appeal into court. Either a 512 action, which we'll get to what that is, or a mandamus action. The 512 action is where you file into common pleas court, and it involves the right to participate. So it involves the initial FROI, the allowance of the claim, or an additional condition. And a condition is basically a medical condition. If you had a left ankle sprain because you injured your ankle at work, your condition would be the left ankle sprain. So that's a common pleas action. A mandamus action involves the extent of disability. So you're thinking temporary total benefits where you're wanting to be paid because you're off work due to your injury, or permanent total benefits as well, where you cannot work in the future. So those are the different types of issues under a 512, a common pleas-based action, or a mandamus action, which is in the Court of Appeals, which we'll get to. We call them 512 actions at Eastman and Smith because the revised code that you file under is 4123.512. And this basically says what I have just been saying in prettier legal language, that in any injury or occupational disease case, other than a decision as to the extent of disability to the Court of Common Pleas. So that decision as to the extent of disability would be those mandamus actions. The mandamus actions are a lot more nuanced than a 512 action, and these days they're a lot more rare. Back in the day, mandamus actions were a lot more popular, but now that the workers' compensation law is pretty well established and we have a lot of seminal workers' compensation cases that we rely on for the same propositions day in and day out, they're a lot more rare, but they still happen, and we probably will see them for the new temporary total amendment that I was talking about just a little bit ago. And when you have a mandamus action, you're seeking judicial review of the industrial commission order, and it's reviewed de novo, so it's reviewed fresh, and the claimant at all times has the burden of proof. It's a high standard to meet a mandamus action, which is probably why they're rarely filed these days with the cost of litigation, or one of the reasons, because you have to allege that the industrial commission has abused its discretion. And discretion by its very definition means that the commission has a wide range to issue its decisions. They have the ability to cite the law, have a good enough reason, and as long as it makes some sort of logistical sense, the 10th district is going to say, okay, that sounds good. And you're going to have a hard time convincing the 10th district to decide otherwise. Again, it involves that extent of disability, so either temporary total or permanent total. And it can also involve a violation of a specific safety requirement. So Ohio is unique in that in Ohio's administrative code, there are these specific safety requirements that apply to certain industries, and they're separate from OSHA. They are rules that an employer must comply with if you work in that industry. And if the injury or the claimant alleges that the injury occurred because the employer was not complying with one of these specific safety requirements, the claimant can then get additional money in the workers' compensation system. And that's a big deal for employers, especially self-insured employers, because they're big awards. They can be up to 50% more than the awards that they've previously gotten to date. So if you do see a mandamus action, oftentimes it will be interpreting those specific safety requirements and fighting about those. Why you file a 512 appeal, so the right to participate in the workers' compensation system or an additional condition, those types of issues, is because of one, obvious, you have medical evidence to say the hearing officers entirely got it wrong here, which would not surprise Angie or I if the hearing officers got it wrong, or you want to use it as a leverage for settlement. And you can obtain so much more information through the litigation world than you can administratively, because you can do written discovery, you can depose the claimant, and while you can ask the claimant questions at industrial commission hearing on the administrative side, and they're supposed to tell the truth, it's different when you get to sit down with the claimant for hours and hours at a deposition and start using, start lawyering them up a little. And once they're under the gun for 3 hours, you might obtain more information than you did at the hearing. And when you get this more information through litigation, you can then say, okay, now I have a better understanding of the claim, the facts, and now I can look at the law, analyze this claim better, and determine what this claim is really worth for settlement. Then employers typically fare better with juries than they do with hearing officers. One of those reasons is because the workers' compensation law, it's written in that it has to be interpreted in favor of the claimant. Two, hearing officers are supposed to be, non-biased overall, but especially in Toledo, we feel that they really favor the claimant. And Toledo overall is really liberal. So we always say if we lose in Toledo, don't blame us. And it also could prevent payment of a really high award the claimant has gotten if you don't want to pay out that award within the timeframes that are required. You can file litigation to prevent that. And eventually, the litigation, once it gets really long and keeps on going, the claimant may get tired and decide this isn't worth it anymore and decide not to continue in the system. So that's another reason to consider filing an appeal as well, or at least another benefit to filing an appeal. Mandamus actions, there are entirely different reasons to file a mandamus action. Because you have to have this difficult standard that the Industrial Commission abuses discretion, they're much less common, as I've already said, and they're also much more expensive. There's a lot more research that goes into it. The arguments, the briefing is more in-depth, more detailed, more strenuous. So the cost for mandamus actions are also more. And again, they're probably a precedent-setting or evolving area of the law. So if you do have one of these niche issues, that's especially when you would consider filing a mandamus action, if you can meet the standard. The deadlines for filing are the same for either a 512, the right to participate action, or a mandamus, the extent of disability action. There's 60 days from the date of receipt of the Industrial Commission refusal order. So remember, when the Industrial Commission at the administrative level says, we're not going to hear this one, that's when you can then take 60 days from the date of receipt of that. The receipt is important because it's not the date on the order, but the date that you can show that you received it. And the only nuance is that for 512 appeals, it's technically an appeal of the SHO order, but it's basically just due to, lawyers being lawyers and how things are drafted. But really, you just have to remember that date of receipt of the Industrial Commission refusal order. The appropriate venue for the 512, the right to participate action, is where the injury occurred, unless the injury occurred outside of Ohio. That is where the contract of employment was made. But I don't want you to take this slide and think that if the injury occurred outside of Ohio, it's easily covered by the Ohio workers' compensation system. There are many arguments to be made that injuries that occur outside of Ohio are not covered by Ohio workers' compensation system, but it's a very fact-specific analysis. But just know that it's not a slam dunk if your injury occurs outside of Ohio for it to be covered by Ohio workers' comp. And as I said earlier, the mandamus actions are an interesting way to get into the 10th district. You get to go straight there. And it's only in Columbus, so you can't go to the 5th district here in Toledo. It has to be where the Industrial Commission's home court is located. So now I'll pass it off to Angie to discuss the process for the most part, and I'll chime in when she wants me to, or when I feel I should. So
Okay.
Angie can take it away.
Okay, thank you. Okay, so your 512 appeals, remember these are right to participate issues. Could we go to the next slide, please? Thank you. These are right to participate issues for a specific condition, either the initial allowance of the claim or a condition that the injured worker would like to have added to the claim after the fact. So who's who and who's on first? The injured worker is always the plaintiff, and the employer is always the defendant. The Attorney General's office is always involved and is always a defendant in the process. The Attorney General's office represents the administrator of the Bureau of Workers' Compensation, even in a self-insured claim. If the claim is a state-funded claim, most of the time, the Attorney General's office will handle the entire litigation from start to finish. But with a self-insured claim, more often than not, the employer will hire their own attorney, and that attorney will defend the action in court. In one distinction, in a mandamus action, the Attorney General actually represents the Industrial Commission. So that's just a little nuance there. So once an appeal is filed in Court of Common Pleas, actually to get it started, the triggering document is the filing of a notice of appeal and complaint. Usually they're filed together. And that assumes that it's the injured worker that is filing the notice of appeal. If the employer disagreed with the Industrial Commission's order and files the notice of appeal instead of the injured worker, then the employer will file the notice of appeal, and then the injured worker is responsible for filing the complaint. And we always, when we file a notice of appeal on behalf of an employer, we always include language in the notice of appeal being very specific that instructs that the plaintiff shall, within 30 days of receipt of the notice of appeal, file the complaint with the Court of Common Pleas. From the very beginning, you should be very conscious of your deadlines and docket every deadline. Check them, double check them. This is absolutely critical. If you, for instance, if the employer has filed a notice of appeal, you want to calendar a reminder so that you know when that complaint is due. And if the complaint is not filed in a timely manner, then you can, I believe, Jade, you can ask the court for a ruling in the employer's favor.
That's correct.
And I've never seen one that they actually didn't file the complaint, but I'm sure it happens. And then you always want to be very conscious of your deadline for filing an answer. As soon as you get the complaint, you want to calendar your deadline, 28 days from service on the employer. It's critical. You've got to file your answer timely. When you're filing your answer, you're going to set forth some of your arguments. One of them would be a question of venue. If, for instance, we have a 512 that was just filed a couple of days ago, they filed it in the Fairfield County Court of Common Pleas. We don't know why. We have no idea. The injury occurred in Columbus. I don't know how they determined to file it in Fairfield County, but we will raise that as an affirmative defense. Also, with your answer, when you're filing your answer, don't forget your jury demand. Many times, if you don't make a jury demand in your answer, you've lost the right to request a jury trial. So, and you'll have a bench trial just before the judge, but you will have lost your right to a jury trial. So that's very important to remember. Once the answer has been filed, the court will, 88 counties in Ohio, and of course, all 88 counties do things differently. So have an idea of what county you're dealing with. In many counties, they will schedule a case management conference or a status conference. And at that point, the court will bring in counsel for the parties, and they'll sit down with calendar and they'll decide the date for the trial, the final pretrial, discovery cutoff deadline for filing motions for summary judgment, things of that nature. And then they'll issue an order setting forth all of those deadlines. Other counties, as soon as the answer is filed, they will just automatically make a trial schedule and send a notice out and let you know what those deadlines are. It's absolutely critical. I can't stress this enough. You've got to calendar every deadline that the court assigns, and even those deadlines that the court doesn't specify. A lot of times, you may get your scheduling order and it gives you the trial date and the date of the pretrial, and it tells you that you have to file your trial brief on or before the date of the pretrial, but it doesn't say, your deadline for filing a motion in limine or deposition transcripts. So if the scheduling order is silent, be aware that there are additional deadlines, and go out and look for those deadlines. You can look at the local rules, or sometimes individual judges will have standing orders and they will have their preferences. They want jury instructions filed in Word format. They want motions in limine 2 weeks before trial. Depositions have to be filed 2 weeks before trial. So go to the local rules or the judge's standing orders to find those deadlines, and make sure that you accurately calendar every single deadline, every single court appearance, everything gets calendared. Check and double check your dates, make sure that everything is accurate. Then the parties will launch into discovery, and that will include written requests for information, such as interrogatories and requests for production of documents. A lot of times the kind of documents that we'll request are either medical records or a medical release for all of the known medical providers, so that we can request those medical records on our own. Something else, another tool in the toolkit, is a request for admission. In a workers' compensation appeal, it's very fact specific. The injured worker, the plaintiff, no longer, they don't have the right or the ability to just ask for the right to participate in the workers' compensation system for their back injury. They have to be very specific about what condition they want to participate for. And that condition is limited to the condition that the Industrial Commission considered. If the only condition before the Industrial Commission was a lumbar strain, they can't ask that a herniated disc be allowed in the court process. So they have to be very specific. And in the complaint, if they're not specific about what conditions they want to participate for, you can have a set of requests for admissions and ask them, please admit that this action is limited to the right to participate for a lumbar strain. Admissions, responses to discovery in general are due within 28 days of service. You can ask for an extension, and most parties are reasonable about extensions. And the world doesn't come crashing to an end immediately if you miss your deadline by 1 day. But requests for admissions are a little bit different. They are very time specific. If you don't respond to a request for admission within your 28 days, and you have not requested an extension, the other party can go to the court and ask that those admissions be deemed admitted. And you're basically saying, well, we asked them to admit that the action is limited to the right to participate for a lumbar strain, And they didn't answer it. So we're just going to ask the court to say that they have admitted that for all intents and purposes, that is fact. And that is a stipulation that we're going to go proceed with. Then you might also have discovery depositions of your plaintiff and possibly of their doctor, their expert witness in certain situations. After discovery is completed, you'll move into the dispositive motion phase. And that will mostly include a motion for summary judgment. Sometimes a motion to dismiss, but most likely it's going to be a motion for summary judgment. And that the standard for a summary judgment motion is that there is no genuine issue of material fact. Sometimes you say, well, there's no medical evidence from a medical expert saying that this condition is causally related to this, the injury that occurred on this specific date. Or there might be other facts that you're dealing with. It's very fact specific. Sometimes you file a motion for summary judgment because the facts absolutely support that. Sometimes you file a motion for summary judgment kind of to get the ball rolling, to get the other side to do something, to make them go to their expert witness and get a report that they've not produced before. Sometimes, maybe they didn't bother to disclose a witness, and you file your motion for summary judgment. You say they've not disclosed a witness, they have no medical evidence, so there's no reason to proceed to trial. We want an order now granting us relief, saying that they are not entitled to participate. Sometimes it's not a real strong summary judgment motion, but sometimes it can be useful to file one just for settlement leverage. Maybe you've been asking opposing counsel for a settlement demand for months and they haven't given it to you. They keep saying, yeah, we'll get one to you. Yeah, we'll get that. Yeah, we'll give you a demand. And they just haven't done it. So sometimes if you file a motion for summary judgment, that will prompt them to actually make the settlement demand or possibly to dismiss the case. Sometimes opposing counsel finds that it's not worth the effort to go out and get an affidavit from their expert witness to say that, yes, this condition is causally related. And so they just dismiss the case, especially if it's the initial filing. And that reminds me of a good point. Once the complaint is filed, the process begins. The injured worker, either party actually, has the right to dismiss the complaint one time. And then they are required to refile the complaint within 1 year's time. And then the process starts over when the complaint is refiled. But a lot of times, especially the first time up, you file a motion for summary judgment and it will prompt a very quick dismissal. Then you would move into, and with a dispositive motion, you file your motion for summary judgment, you file the exhibits that support it, and then the other side has the opportunity to file an opposition brief. They have 28 days to do that. And then within 7 days, the party that filed the motion for summary judgment has the ability to file a reply brief and just say, well, this is their opposition, we disagree. The judge will then review all of the briefs and they will make a decision. If the motion for summary judgment is granted, that becomes a final appealable order. The case ends right there. You don't go to trial. Don't pass go, do not collect $200. If the judge denies the motion for summary judgment, obviously the case proceeds to trial. If the judge grants a motion for summary judgment, it becomes a final appealable order. But the other side has the ability to appeal to the Court of Common Pleas. The one thing that's very critical is to file the appeal in the correct Court of Appeal. Ohio has 12 different courts of appeal. And there's a nice, neat little map, and it's all districted, lines drawn as to what counties belong in what district for the Court of Appeals. Larger counties, Franklin, Cuyahoga, Hamilton, the district court of the district court of appeals is just one county. But in other areas where there are a lot of smaller counties, a lot of outlying areas, there may be multiple. For example, the second district court of appeals in Ohio is housed in Montgomery County. It encompasses anything that happens in Montgomery, Miami, Darke, Champaign, Clark, or Greene County. So just be aware of that if you're going to file an appeal from a decision granting or denying, a decision granting summary judgment, you want to make sure that you're in the right court. Okay, moving through the process. After discovery is completed, then you will want to move into your expert witness depositions. Another thing that you'll be looking at are motions in limine. And what that is a motion instructing the court, for example, if the other party didn't file a disclosure of expert witnesses, then you can ask the court to issue an order saying that they cannot, at the last minute, at the 11th hour, they cannot come to trial with a report or deposition testimony or trial testimony from an expert witness because they did not timely disclose that expert. So that would be a motion in limine that would be decided before trial begins. The judge would make a decision, and that is a decision that both sides would have to live with. Another pretrial filing would be jury instructions. These are proposed jury instructions. The court will decide whether they will accept the jury instructions that you have provided. They might add something, they might delete something. And both parties will need to file a trial brief. And there can be other filings as well. And then you proceed to trial. You're either going to have a jury trial or a bench trial. If you've made a jury demand, then you are going to have the ability to have a jury trial. If you didn't make a jury demand, or if you waive the right to a jury, then it's a bench trial and the judge is going to hear the arguments and make his own decision.
One more motion in limine that we typically do at the firm is if the issue is an additional condition, we'll have a motion in limine that they don't consider the rest of the conditions so that it's just focused on that additional condition. So it's just a good strategy to focus the jury, because oftentimes, especially if the other conditions are more serious or the accident was particularly not so great, the jury will get distracted and it will cause more favor in the plaintiff's favor. But if you're on the plaintiff's side, then obviously you would fight that motion in limine as hard as you could, because you want them to consider all of the facts and make your plaintiff more appealable to the jury.
Right. So some of the work that paralegals are going to be involved in preparing for trial and trial support, you're probably going to be asked to draft pleadings, whether, depending on what kind of a firm you work for, either the complaint or the answer. You'll be asked to draft discovery requests, possibly discovery responses. You'll be asked to obtain medical releases, request medical records, and then analyze those medical records, prepare a medical summary, summarize what the medical records say, and put those medical records in a notebook so that they are very well organized and you can access specific documents that you're looking for very quickly. You may be asked to prepare a deposition summary. That's something that my attorneys have not asked for in the past, but I have done it in the past. But the most important thing, well, not the most important thing, but another important thing that you'll be asked to help with is to prepare the trial notebook. And there are a lot of theories about the best way to prepare a trial notebook. Do you want a paper trial notebook? Do you want an electronic trial notebook? What documents do you want included in the trial notebook? How many copies of the trial notebook do you need to make? And it's a living, breathing document, and it's going to change from day to day. You're going to make up your trial notebook, and then you're going to have your attorney say, "Oh, put this in the trial notebook." And so you'll make additions to it. Sometimes you'll take something out, but it will evolve over time. But it's very important to stay very organized and very focused on these things. You may be asked to help prepare exhibits either for deposition or for trial. I know most of the time when my attorney is getting ready to take a plaintiff's deposition or a doctor's deposition, he doesn't even ask. I go ahead and, print out a copy of, for the plaintiff's deposition, a copy of their discovery responses, a copy of our expert's report, a copy of maybe definitely the claim application, maybe an incident report, documents that are going to be something that he is likely to ask them about during the deposition. And is the same thing if it's a deposition of a doctor, you'll want to make sure that you've got a copy of his report. And the record, the medical evidence that he relied on in preparing his report, whether that's the MRI report, an EMG report, a consult report from Dr. Smith or Dr. Jones, office notes of Dr. Howell, whatever documents the doctor relied on in forming his opinion. You'll want to have those documents available to the attorney so that he can decide what he wants to ask the doctor about and where he wants the doctor to focus his testimony. Then you might also be asked to assist at trial. You'll want to become very familiar with your trial presentation software, whether it's Sanction or any of a number of multiple different trial presentation software that's out there. You may be asked to, it's essentially putting on a slideshow of adding documents to it, exhibits that you're going to be using, and maybe zoom in and highlight the relevant portion of that page of the deposition transcript or of the doctor's report, and just to have everything ready to go when it comes time for trials. So don't wait until the last minute to learn how to use your trial presentation software. Make sure that you have everything necessary uploaded to it. Make sure that you know the ins and outs of how to run it. Go to the court in advance, look at the trial, make an appointment, contact the judge's bailiff or assistant and ask for a time that you can come into the courtroom and see the lay of the land. Where are the outlets? Am I going to need 5 extension cords, or is there an outlet conveniently located right behind me? Know how to tear down the equipment. What cables do I need? How do I, hook everything up? What gets plugged into what? Know how to do that before you get to trial. That will be absolutely essential. Okay, we'll talk a little bit about mandamus actions now. Again, who's on first? In a 512 action, the injured worker is always the plaintiff and the employer is always the defendant. Not so with a mandamus action. The party that files the mandamus action is known as the relator. And then the defending parties are going to be the respondents. And again, the Attorney General will be involved on behalf of the Industrial Commission this time, because what you're asking for in a mandamus action is an order saying that the Industrial Commission got it wrong. they didn't make the right decision. And so they are defending the Industrial Commission at that point. And as Jade mentioned, it is a de novo process, as is a 512 action. When you get to, even with a 512 action, when you get to court, the judge doesn't really care that the district hearing officer thought that was a lousy report and allowed the claim. He's going to look at everything with a fresh set of eyes, as though nobody has considered this in ever before. So with the mandamus action, there's no trial. You don't get your day in court. You don't get the option to ask for a jury. It's not going to happen. It's decided entirely on the basis of the briefs and the exhibits that are entered into the court record. The first thing is that the filing party will file a complaint for a writ of mandamus, and you've got to keep in mind these are so rare because it is a very high bar. There's a very high standard. Well, actually, depending on how you look at it, it's a very high bar. You're asking the court to decide that the Industrial Commission had abused its discretion. There was no evidence, absolutely no evidence that they could have relied on in making this decision. And then the court may find, the Industrial Commission has a lot of discretion as far as what reports they're going to rely on, what they're going to give credibility to, what they are going to consider. And even in their orders, they have to set forth, they have to list the evidence that they relied upon in making their decision. So this is a very high bar. If you're going to file a mandamus action, particularly for a permanent total application, if somebody has filed an application for permanent total, a lot of times we will have a court reporter attend the Industrial Commission hearing. So there's a written record of the testimony, so that if it gets to mandamus, the court has a record and they know exactly what happened and who said what. Same thing if it would involve a loss of use. If there's been a loss of a use award for the entire left arm, that's a big deal. That's a huge award. So that might be something that you might want to file a mandamus action on, and definitely have a court reporter at the Industrial Commission hearing. So the filing party files a complaint for a writ of mandamus. The court assigns a magistrate, and then there's a briefing schedule. There's the opposing party files an answer. Then there's a submission for stipulated evidence, and this is where you tell the court, look at this evidence, look at this medical report, look at this office note. Usually when we're doing a stipulation of evidence, we're being overly thorough, and you're taking a painstaking look at every document that is in the Industrial Commission's file. And you're including everything and identifying specifically every document. If you're dealing with a loss of use award, and Dr. Smith in his October 1st, 2019 office note says, oh, he has full functionality of this arm, then if you have not introduced that office note, the court can't see it. The court won't rely on it. They won't consider it. So you've got to be painstaking and make sure that every piece of evidence that you might want the court to look at is included in your stipulated evidence. And most of the time, the parties will draft a stipulation of evidence and pass it to, the other side, and the other side will look at it and say, well, this is great, but you left out this and this and this. We want to include that. You get a stipulation of evidence put together, file it with the court. That's what the court is going to look at, and that alone. The parties are going to file their merit briefs, and then you can request oral arguments. but they are not automatic. You don't automatically have oral arguments in a mandamus action, only if an oral argument is requested. So perhaps the court allows you to have your oral arguments. You go to the court, each side has their specified amount of time, you make your arguments, and then the court will make a decision. Typically with a mandamus action, especially if there is no oral argument, there's a magistrate that's assigned to the issue, and the magistrate will issue a decision. The parties can say, whoa, magistrate, you got that wrong. We don't agree with your interpretation. And so the parties can file an objection to the magistrate's decision. And that triggers, of course, once you file an objection, there's another piece of paper filed. The opposing parties can file a response saying, oh no, yeah, the magistrate had this absolutely correct. They were spot on, nailed that, and there's no reason to throw out the magistrate's decision. So then a 3-judge panel is going to review all of the briefs, and they're going to issue a decision. Possible outcomes for a mandamus action. The court may deny the writ of mandamus outright. They might grant a limited writ, ordering the Industrial Commission to vacate its order, reconsider its order, issue a new order. They might grant a full writ and say, Industrial Commission, you need to vacate your order and issue a new order based on what our decision is. You need to issue a new order saying what we have decided. Either party, of course, there's an appeal. You can appeal to the Ohio Supreme Court. That is not an automatic, or is that an automatic right of appeal?
No, it's not automatic.
Okay, so the Supreme Court would have discretion as to whether they would hear that appeal.
Correct.
Okay. So that is, in a nutshell, everything that we have. Who has questions for us today? Come on, we've got 7 minutes left. I know you have questions. Either go ahead, unmute yourself and ask away, or put it in the chat. We will entertain any questions that you have. And the crickets. Jade, did you have anything that you wanted to add? Did I miss anything?
No, I think it was great. I interjected when I felt was appropriate. So,
okay. I would just say, understand that court appeals for litigation for workers' compensation issues, they're very fact. Why can't I speak today? They're very fact specific.
mm-hmm.
They are both de novo. The court is going to look at it with a fresh set of eyes, as though nobody has ever considered these issues before. They don't care what the Industrial Commission hearing officers thought about Dr. Smith's report. They don't care if the SHO thought that the claimant was not credible and disallowed the claim. They are looking at everything brand new. The most critical thing is to mind your deadlines, docket everything, make sure that your deadlines are docketed accurately, make sure your deadlines are correct, get everything docketed accurately. Check out, have your checklist of things to do, check them off as they're done. Oh, that's a good question. Jade, what do you think? How many 512 cases get to trial? Not
I would
many.
say not that many, which is the typical answer, that we see litigation wide. However, I think more like 512 cases go to trial than, say, a typical employment discrimination case. because there's so many reasons why one would want to file a 512 case. So if from that perspective, more than average, but since trials are trending downward overall, still just a small amount. But I say we get multiple 512s, a month. We definitely have a lot that we still are getting, whereas mandamus actions are very rare these days. Whereas back in the day, like I said, they're way more common. So how many? I can't put an exact number on it, but I would say actually making it, I would say probably like 15 to 20% of them that are filed. Maybe that's high.
Yeah. I know, in my experience, I think that the vast majority, maybe not the vast majority, a lot of them just dismiss because the claimant doesn't want to continue. But I think most of them these days end up settling before it even gets to trial. I know that we have had a lot of success over the last 2 or 3 years with summary judgment motions. And we're getting actually pretty good at defending them in the Court of Appeals as well. So yeah, they not many go to trial. We do have one though, that is going to be going to trial. We're absolutely certain of it. The injured worker filed his appeal. The Summit County, it requires mediation before they issue a scheduling order. We went to mediation. His counsel was extremely outrageous in his settlement demand. And so within 5 minutes, we were done with mediation. They set a trial schedule. We started going through the discovery process. We were at the point that we were scheduling our expert witnesses for deposition. We were preparing for trial, and they dismissed. He immediately, like within 3 weeks, refiled the complaint. And of course, that put us back in mediation. And that was just last month. And of course, it was another 5-minute mediation that went nowhere. And this man is he's adamant. He wants his day in court. And so Mark is certain that this one will go to trial. So I'll be interested to see how that turns out. But yeah, make sure that you keep track of all of your deadlines. Make sure you docket everything. Make sure that you stay organized. Keep things labeled. Perhaps you're going to make an electronic file where you're going to store all of the relevant documents in addition to their usual resting place. Start your trial notebook early. Organization, keeping your deadlines straight. You don't want to miss a deadline. That's always bad. Docket. Any other questions? Well, I don't see any, and I see that we are basically at the end of our time. So I will thank you again for attending today's session. Thank you again, Megan from Spectrum Reporting. We appreciate you guys so much for all that you do for us. As far as next month's session, I don't have a topic yet, and I don't have a speaker yet. I will work on that diligently over the next week, and I will get that announcement put on our website and announcements sent around. Check back at the website for more information. Probably, I like to try to find a fun yes, Jesse, I would love to have suggestions for topics. They're always welcome. Either give them to me now, send me an email. I don't care. Let me put my email in the chat so that you have it. Did I get that right? Yes. So yes, if you have suggestions on topics, throw them my way. I'd love to hear that. We will do something fun next month in June, and then we will take July and August as a break, just because of summertime and everybody's vacation schedules. Heather and I are going to, Heather Jones has so graciously offered to step up and help me with the workers' comp roundtables. And she and I are going to be meeting soon, so that we can talk about potential topics and speakers for next year. And I would encourage you to stick around. Lots of good things coming. Check the website. We will get more information out to you. Thank you so much. Can't wait to see what ideas you have for topics. Have a great day, everyone, and we will see you soon. Thank you.
Thank you all.